Welcome to the 12th and last episode of the series, Playbook for Monetizing Your Music Rights. So far, you now have the knowledge to build a sustainable, profitable music career while protecting your rights. But here's the reality. Even when you do everything right, disputes happen. Someone infringes your copyright. A label or distributor doesn't pay you what you're owed. A contract partner violates the agreement. A collaborator disputes ownership. A brand uses your image without permission. Today, in this final episode, I'm going to show you exactly what to do when things go wrong, how to handle disputes effectively, when to negotiate, when to take legal action, and how to resolve conflicts while protecting your interests and preserving relationships where possible. This is the episode I hope you never need, but the knowledge that will save you when you do. Let's start by understanding dispute resolution options. Part A. The dispute resolution hierarchy. When a dispute arises, you have several options for resolving it. Think of them as a hierarchy, from least formal to most formal. Level 1. Direct negotiation. You and the other party communicate directly to resolve the issue. This is the fastest, cheapest, and least confrontational option. Level 2. Negotiation through representatives. You engage lawyers, managers, or agents to negotiate on your behalf. This adds professionalism and legal expertise while keeping things out of court. Level 3. Mediation. A neutral third party helps you and the other side find a mutually acceptable solution. The mediator doesn't decide the outcome, they facilitate agreement. Level 4. Arbitration. A neutral arbitrator hears both sides and makes a binding decision. It's like a private court proceeding, usually faster and less expensive than litigation. Level 5. Litigation. You file a lawsuit and go to court. A judge or jury decides the outcome. This is the most formal, expensive, time-consuming, and adversarial option. The goal is always to resolve disputes at the lowest level possible. Each level up increases cost, time, and damage to relationships. But sometimes, escalation is necessary. The key is knowing when to move up and when to hold your ground at a lower level. Part B. Common music industry disputes. Let me walk you through the most common types of disputes I see in my practice. 1. Copyright infringement. Someone uses your music without permission. Sampling without clearance. Unauthorized sync placements, piracy, or plagiarism. 2. Unpaid royalties. A label, distributor, publisher, or collecting society owes you money and either hasn't paid or is disputing the amount owed. 3. Contract breaches. A party to your agreement, label, manager, producer, distributor, fails to fulfill their contractual obligations. 4. Ownership disputes. Disagreements about who owns what percentage of a composition or sound recording, usually among collaborators or between artists and producers. 5. Image rights violations. Unauthorized use of your name, likeness, or brand, often by companies using your image in advertising without permission. 6. Manager or agent disputes. Conflicts with managers or booking agents over commissions, contract terms, or performance of duties. 7. Label release obligations. You've delivered music to your label, but they're not releasing it or promoting it as promised, and you want out of the contract. Each type of dispute has its own best approach, but the principles I'm about to share apply across all of them. Part C. The strategic approach to any dispute. When you find yourself in a dispute, follow this strategic framework. Step 1. Document everything. Before you do anything else, gather all relevant documentation, contracts and agreements, email correspondence, royalty statements, registration documents, screenshots of infringement or violations, financial records showing payments or lack thereof. You cannot resolve a dispute effectively without a clear record of what happened, what was agreed, and what evidence supports your position. Step 2. Assess your legal position. Consult with an entertainment lawyer to understand. Do you have a strong legal case? What does the law and your contract actually say? What are your chances of winning if this goes to court? What remedies are you entitled to? Money damages, injunctions, specific performance. Sometimes what feels like a clear-cut case isn't as strong legally as you think. Get objective legal advice before taking action. Step 3. Determine your goals. What do you actually want from this dispute? Do you want money? How much? Do you want them to stop doing something? Do you want out of a contract? Do you want an apology or public correction? Do you want to preserve the relationship, or are you okay burning bridges? Be clear about your goals before you engage. This clarity guides your strategy and helps you evaluate settlement offers. Step 4. Start with direct communication. Unless the situation is extremely adversarial, start with a professional, direct communication. Send an email or letter outlining the issue, referencing the relevant contract clauses or legal provisions, and proposing a reasonable resolution. Many disputes resolve at this stage because the other party either didn't realize there was a problem or is willing to fix it when confronted professionally. Part D. When to escalate. Here's when you should move up the dispute resolution hierarchy. Escalate to legal representation. When direct communication doesn't get a response or produces an inadequate response. The other party is clearly taking advantage of you and won't negotiate in good faith. The dispute involves significant money, hundreds of thousands or millions of naira. The legal issues are complex and require professional representation. Escalate to mediation. When both sides want to resolve the dispute but can't agree on terms. Emotions are high, and a neutral third party could help find middle ground. You want to preserve the relationship if possible. Both parties are willing to participate voluntarily in mediation. Escalate to arbitration. When your contract includes an arbitration clause requiring it. You want a binding decision but want to avoid the expense and publicity of court. You need faster resolution than litigation provides. Escalate to litigation. When all other options have failed or are unavailable. The other party is acting in bad faith and won't negotiate. You need the court's power to enforce a judgment or obtain an injunction. The principle is more important than the cost. You're willing to spend money on legal fees to establish your rights. The amount at stake justifies the expense of litigation. Litigation should always be the last resort, not the first response. I've seen artists spend 3 million naira in legal fees to win a 5 million naira judgment. They won but netted only 2 million naira after 2 years of stress. A settlement of 3 million naira resolved in 3 months would have been a better outcome. Section 3. Practical application. Your dispute resolution toolkit. Let me give you the practical tools and tactics for handling disputes effectively. Tool 1. The cease and desist letter. For copyright infringement or unauthorized use of your image, a cease and desist letter is often the first step. This is a formal letter from you or your lawyer demanding that the other party stop the infringing activity immediately, compensate you for past use, confirm in writing that they will comply. Cease and desist letters often work because they put the other party on notice that you're serious and that continuing the violation exposes them to legal liability. Many companies prefer to settle at this stage rather than risk litigation. Tool 2. The demand letter for unpaid royalties. If you're owed royalties, send a formal demand letter that includes a clear statement of how much is owed and the period covered, reference to the contract clauses requiring payment, supporting documentation, royalty statements, streaming data, whatever proves the amount owed. A reasonable deadline for payment, typically 14 to 30 days. A statement that you'll pursue legal action if payment isn't received. Be professional, not emotional. Stick to facts and figures, make it clear you're serious but open to resolution. Tool 3. Audit rights. Many contracts include audit rights, the ability to review the other party's financial records to verify payments owed to you. If you suspect you're being underpaid by a label, distributor, or publisher, exercise your audit rights. Hire a specialized music royalty auditor to review their books. Audits often uncover significant underpayments, and many contracts require the other party to pay for the audit if the underpayment exceeds a certain percentage, often 5 or 10%. I've seen audits recover hundreds of thousands to millions of naira for artists who suspected but couldn't prove they were being shortchanged. Tool 4. Settlement negotiation tactics. When negotiating a settlement, start high. If you're owed money, ask for more than the minimum you'll accept. Leave room for negotiation. Know your walkaway point. Before negotiating, decide the minimum settlement you'll accept. Don't go below it in the heat of negotiation. Focus on interests, not positions. Understand what the other party really needs and find creative solutions that give both sides something valuable. Get everything in writing. Once you reach an agreement, document it immediately in a settlement agreement signed by both parties. Never accept a verbal settlement promise. I've seen parties back out of verbal agreements repeatedly. If it's not in writing and signed, it doesn't exist. Tool 5. Preventive measures. The best dispute resolution is dispute prevention. Always get contracts in writing. Never rely on handshake agreements or verbal promises. Include dispute resolution clauses in your contracts. Specify whether disputes will be resolved through mediation, arbitration, or litigation, and in which jurisdiction. Document everything in real time. Don't wait until there's a dispute to start gathering evidence. Keep good records from the beginning. Communicate clearly and promptly. Many disputes arise from misunderstandings or lack of communication. Keep lines of communication open. Register your works properly. Copyright registration, trademark registration, and proper metadata make it much easier to prove ownership and enforce your rights. Review contracts before signing. Have a lawyer review every agreement. Prevention is cheaper than litigation. If you enjoyed this video, please don't forget to like, comment, and subscribe.